Welcome to the Supreme Court of the United Kingdom. Today we are hearing the appeal in the case of Stoffel Company and Grondona, details of which can be found on our website by clicking on the link to current cases. At the moment we're hearing the submissions of Mr. Andrew Warnock, Queen's Counsel, on behalf of the respondent, and after he has completed his submissions, we'll hear Mr. Michael Poole's Queen's Counsel in reply on behalf of the appellant. Mr. Warnock.
My lord, my ladies, before the short adjournment for lunch, I had been making a number of points on Patel and Mirza, and I'm about to turn to their application to this case. And before I do so, can I just check first of all that everyone can hear me? By way of context, Ms. Grondona's claim
Thank you, Mr. Warnock.
By way of context, Ms. Grondona's claim would have succeeded pre-Patel and Mirza, and indeed the trial judge so found in her decision, which predated the Supreme Court's decision in Patel. The reason it would have succeeded is because, as the trial judge said, the claim against the solicitors for failing to register the title, the very obligation they admit that they owed to her, was conceptually different from the fraud, which was really background to why they had that obligation in the first place. So applying Tinsley and Milligan, it's not something she would have had to rely on. All she needed to establish.
From your submissions, it rather sounds as though you're taking the idea of a mortgage out of a mortgage fraud. The point of the mortgage fraud is that it's a scheme whereby the lender is deceived into granting a mortgage to somebody who isn't as creditworthy as they think, who isn't going to be the person using the funds. The funds are going to be used for a different purpose. And the mortgage is the central, is actually central to the fraud.
Well, the mortgage is the charge, it's the security against the property. The fraud is actually getting the money. I mean, there are mortgage frauds where people simply disappear with the money, and there are mortgage frauds where borrowers don't exist, or properties
don't get the money. But the means by which you get the money is the entering into a fraudulent mortgage. And it so happens here the mortgage is being is meant to be registered. I dare say this will be usual because of the time that things take in the land registry and so on. The advance has disappeared by the time the mortgage is due to be registered. But nonetheless, the completion of the fraud is meant to bring about a situation where the mortgagor has granted a loan to the one of the fraudsters on the security of a mortgage granted by a charge granted by that fraudster over the property.
Well, I agree with that in part, and in some parts not. The fraud is, and obviously the object of the fraud is to get the money. The object is not to get the charge, because what the charge is, that's protection for the person who's lending the money against property. So the fraud is the obtaining of the advance, and that is done by telling the lies on the application form and persuading the lender to lend to you. So somebody doesn't set out on a mortgage fraud to get a mortgage. They set out on a mortgage fraud to get the money, and then the charge comes later. Now, the reason I was saying is that we know that this lady would have won under the old law. Indeed, she did win under the old law in front of the judge. And the reason for that is because her complaint against the solicitors is nothing about you didn't get me the mortgage advance or you didn't help me get that. The complaint is purely that they didn't carry out what they were retained to do, which was to register the transactions. And that, sorry, my lady Black.
Really help me just to have the facts clear, because I think there are three transactions potentially in play here. Yes. The first is that once the cash is sent to the first chargee, that charge should have been discharged. If that had happened, then none of the rest of it would have followed, because he wouldn't then have spent the extra monies against, or might not have followed, because he wouldn't have spent the extra monies against that charge. So that's number one.
Yeah.
Number two is the failure to register the new charge by the second lender. That's the lender to Mr. Mitchell, well, as it turned out to Mr. Mitchell, but to the claimant. And the third thing is the failure to register the transfer of the legal title to the claimant. Am I right, first of all, in identifying the three transactions that we're interested in?
The three transactions, although I think the order probably would have to have been registration of the transfer before you could put a charge against it. Yes. So the discharge of the existing charge, the register of the transfer to Ms. Grondona, and then registration of the Birmingham Midshire's mortgage against the premises.
And her claim relates only to the transfer of the title?
Yes, what she lost was, and there's no dispute in this case, that she did suffer loss. That she lost the transfer of title to her, and the consequence of that when that she didn't have the property available to her to discharge the mortgage. I mean, one can test the question of loss like this. Supposing the facts were slightly different. Supposing that within 5 or 6 years, Ms. Grondona had repaid, and then she'd got to sell the property, and at that point discovered it wasn't registered. You can see that that's where her loss comes from. It's from the failure to register the transfer to her.
So supposing that it had been registered and then somebody had gone and burned it down, would that be a Bowmakers and Barnett Instruments sort of situation, conversion? And she could have sued for that?
Yes.
Notwithstanding that she'd acquired it by means of illegal funds.
Yes, because I mean, one hesitates to speculate, but one guesses there must be many properties bought with sources of illegal funds. In fact, it was an issue in the Arkelski case. I can't remember the Angelski case, which we've got before you, was that the defendant bank in that case said, "Well, hold on, you're suing us for the loss of port by dishonest means, by means of using bribery to get licenses to use them. And therefore, we have an illegality defense." And the Court of Appeal dismissed that on the basis that how the claimant had come to have the property was irrelevant to the issue the court had to decide. So if the law, fundamentally the point we make in this case is that if illegality is about coherence and lack of inconsistency in the law, there is something incoherent about a legal system that recognizes that the property transfers to someone, but then says, but we won't recognize the rights which consequently flow from that. And as I say, by way of context, I think I've made this point now. We know the case would have succeeded under the old law. It did succeed under the old law. The reason it succeeds under the old law is that it is completely irrelevant to the solicitor's obligation to register these conveyances, how they were funded or how they came about in the first place. If Miss Grondona had been suing in relation to a point my Lord Hodge made this morning, if she'd been suing the solicitor for doing what the mortgage company had said he should have done, and spotting earlier that there was, he was acting for a vendor and a purchaser, and she was suing him for somehow stopping the advance being made, then in those circumstances, one could see the case that she would be asking the court to assist her in proceeding with something illegal. But in this case, that's not this case. She's asking the court to assist her, and everybody accepts she has a cause of action for this, but for the illegality defense, which the defendant says should result in it being taken away from her, she's asking the court not to enforce the dishonest transaction between her to get the mortgage funds, but to recognize the property rights which the law says were transferred to her. And the question, my Lady Arden.
Just going to say, no doubt you would say that it would expose an inconsistency and paradox in the law if the law on the one side recognized the transfer but didn't uphold property rights, and that is a valid inconsistency and lack of harmony.
Yes.
Just of the post-Partel and Mertzer analysis. You did try to persuade us, and I'm only speaking for myself, that you can ring out the old and ring in the new, and it's the same thing, but it's not necessarily, is it? Because you get different considerations and different.
Clearly, I'm sorry, my lady.
No, carry on.
I'm not saying it's exactly the old. Clearly, there will. Although I suspect what the Supreme Court had in mind when they decided Patel and Mertzer, reading the judgment as a whole and all of the judgments as a whole, is that that the illegality defense would tend to be less successful in the future rather than more successful, because the primary concern was that the reliance test was presenting an automatic bar to people recovering and distorting the law in that regard. But of course, there will be cases where applying the new methodology, a different result might be reached than under the old law. But I do submit they're likely to be rare, and this is not one of them. A fundamental reason why this is not one of them, as well as the inconsistency point which my lady has just identified, is the centrality point, the centrality of the illegality to the claim. But I'll come on to that when I come to proportionality.
Thank you.
So the starting point in this analysis of this case is that Miss Grondona had a proprietary interest in the property, and the Court of Appeal dealt with this, and it's at page 115 of the bundle, at paragraphs 34 to 36. I should really start at paragraph 33, page 115 of the bundle, where Lady Justice Gloucester said, in my judgment, it's clear from the analysis above that in general, and no doubt there are exceptions, once property or an interest in the relevant property has passed to the illegal transferee, he has all the remedies available to him as the valid holder of that property or interest. This applies both in relation to the illegal transferor and to third parties. It is because the transferee is entitled to all the benefits of a holder of the relevant property or interest as against all the world, save those who could prove a better title. And then in the present case, there can be no doubt that had the defendant registered the TR1, and that's the transfer document from Mitchell to Ms. Grondona, at the land registry following the execution and delivery of the TR1, the legal title in the property would have passed under section 27(1 of the Land Registration Act 2002, despite the illegal agreement. However, the absence of registration meant that all the claimant was entitled to was an equitable interest in the property, namely the right to be registered as proprietor of the registered title, see section 24B of the Act, and then the Mortgage Business and O'Shaughnessy case. Paragraph 35, but the fact that the claimant merely obtained an equitable interest in the property under what the judge held to be her illegal contract with Mr. Mitchell does not, in my judgment, mean that she fell outside the parameters of the principle described above. And having looked at the reference back to Tinsley and Milligan this morning and Lord Sumption's point judgment, although it's clear in the case, in the passages he cites, that's clearly right. On the contrary, Mr. Mitchell had done all within his power to transfer legal title to the claimant, and certainly could not have reneged on his obligation to do so, so as to prevent her from protecting her position under the proposed Birmingham Midshire's first legal charge. In these circumstances, what the defendant was obliged to do and failed to do, so far as the claimant was concerned, was to protect the claimant's equitable interest in the property and her liability under the Birmingham Midshire's charge by registering the TR1, the discharge of the BM Samuel charge, and the Birmingham Midshire's charge as a first legal charge, so that she became entitled to a legal interest in the property and her position as chargee, liability under a personal covenant was protected. And as I say, that's not disputed by the solicitors. They accept they owed her the obligation to do that. She says the illegal features of the agreement between the claimant and Mr. Mitchell were irrelevant to that obligation. I do admit that observation is clearly correct. And then the question becomes whether applying the criteria articulated by Lord Toulson, there is any reason why she should not be entitled to recover damages in respect of the admitted negligence. And that brought the Court of Appeal, as indeed it brings me, to the policies. And the Court of Appeal rightly started with the proposition that mortgage fraud is a canker on society. But the question is, and this goes back to what Lord Toulson asked at paragraph 120 of Patel and Mirza, paragraph 120 of Patel and Mirza, page 364. In assessing whether the public interest would be harmed in that way, it is necessary, A, to consider the underlying purpose of the prohibition which has been transgressed, and whether that purpose will be enhanced by the denial of the claim. And as I submitted this morning with reference to the earlier passages in Lord Toulson's judgment, one has to bear in mind that there is a division of responsibility between the criminal law and the civil law in this respect. The important point is the civil law should not undermine the criminal law. And in relation to the policy against mortgage fraud, well, my learned friend says, well, it's all about deterrence. And that's his case, paragraphs 13 and 14, essentially. mortgage fraud and the obtaining of loans by deceit is the subject of the criminal law. And the idea really that by denying a professional negligence claim in these circumstances for the failure to register title, not for the failure to get the money, but for the failure to register title, will discourage mortgage fraud is, with respect, fanciful. If the criminal law doesn't do it, in fact, my learned friend's submission does, with respect, contain a lot of what might fall foul of the need for evidence in some of these issues, because it is asserted that everybody knows it's very difficult to prosecute mortgage fraud, and that there are all sorts of problems with the criminal justice system in relation to that. But it's not the function of the civil justice system to act as the criminal law justice system sort of gap filler. The question is whether allowing this claim in any way undermines the criminal law. And underlying all the policies, clearly they should not, as my Lord Reid said, and as the Court of Appeal acknowledged, the courts should not empower mortgage fraud. But underlying the policy is the need to avoid loss to mortgagees. And that's where a point we take up at paragraph 35 of our written case. It's at page 86 of the bundle. And one has to ask, well, would denying this claim enhance the policy of protecting loss suffered by mortgagees? And we make 2 points in relation to that. Firstly, the negligence occurs after the mortgagee has lost its money. So a claim for failure to register is not going to have any material impact on that. But secondly, and if I may develop this, it was in the interests of not only Ms. Grondona, but also the mortgagee that all these registrations should happen. Now, that's not her piggybacking onto the mortgagee's claim. The fact is their interests are coterminous in this. And you may not have picked up, but the reason the claim against the solicitors was brought is Ms. Grondona is sued by the mortgagee on the covenant. It's discovered that there's no registration. She then joins the solicitors in by way of a Part 20 claim, with a view, therefore, to getting the asset available which meet the mortgagee's claim. Denying the claim to the proprietary interest which has transferred in these circumstances, it's difficult to see how that would enhance protection of the mortgagee, because in fact it results in the borrower not having the assets and the money in the pot to pay back the mortgage. Now, my learned friend says, well, the mortgagee can sue the solicitor, and in this case, certainly they can. But it's nonetheless likely to be the preference of mortgagees to be able to sue the borrower on the straightforward covenant for the money they're owed and get the money back than have to start embarking on professional negligence claims. There are echoes of this. The case is obviously different in a number of respects, but my lords, Lord Reid and Lord Lloyd Jones were in the Singularis and Dewa case. And if I could just briefly turn to it at page 471, it's Authority tab 5, but page 471. And at least those two members of the court will be familiar with the facts that a director and shareholder of the company had been making unlawful and suspicious withdrawals from the company's bank account. The company, when in liquidation, sued the bank for breach of its quince care duty. One of the issues raised concerned whether or not the directors' acts were attributable to the company. That's not relevant for present purposes. But there was an illegality defence raised, and the court considered the illegality defence on the assumption that attribution did apply, so that the fraud of the director was that of the company itself. And the court ultimately upheld the, as the Court of Appeal had, the application of the Patel and Mirza test, which the judge at first instance had made in that case. And at paragraph 16 on page 478, one of the purposes was the illegality relied on in relation to some of the payments was in fiduciary duty towards Singularis. And then the judge held that the purpose of the prohibition of breach of fiduciary obligation was to protect the company from becoming the victim of the wrongful exercise of powers by the company. That purpose would certainly not be enhanced by preventing the company from getting back the money which had been wrongfully removed from its account. Now, I accept there are, it's not on all fours, but the similar point does occur here, which is it will not enhance the protection of mortgagees if borrowers who do have property transferred to them are unable to sue their solicitors for losing it effectively. The Court of Appeal, sorry.
In Singularis, the fundamental point was that the criminal behaviour of a director couldn't be attributed to the company. And so there was no question of the company having been involved in criminal behaviour.
Yes, the Supreme Court found that ultimately there wasn't attributability, but it considered the illegality argument on the assumption that there was attributability. And I think one finds that if one goes to, sorry, paragraph 21 of the judgment on page 478. Lady Hale said, Daiwa's arguments necessarily depend, this is on the illegality, necessarily depend upon a finding that Mr. Al-Saineh's fraud was the company's fraud, an issue which was discussed later. But even if it was, in my view, the judge was correct for the reasons she gave. So when dealing with the illegality defence, the court was proceeding on the basis that the fraud was that of the company. But your lordship is quite right that ultimately the Supreme Court held that there wasn't attribution either.
Yeah. Yes, I suppose what Lady Hale's referring to is what she discusses in paragraph 16 between A and B. You know, the purpose was to protect the company from becoming the victim of wrongful exercise of power by its officers.
Yes.
That purpose wouldn't be enhanced by preventing it from getting back the money wrongfully removed from its account. Well, yes, really, that's assuming that. That's assuming the wrongdoing is by officers rather than by the company itself. Yeah. Well, thank you.
The Court of Appeal considered the countervailing policies, and we picked those up in our case at page 86. And at paragraph 36, we deal with the point that, as the Court of Appeal said, there is a public interest in solicitors and other professionals not being able to avoid their liabilities because they discover after the event that misrepresentations were made by their client. And that is likely to encourage solicitors in conveyancing negligence claims to look for potential misrepresentations in application forms, when really those have nothing to do, we submit, with what actually the breach of retainer is. And as the Court of Appeal also said, closely related to that, there is a public interest in those who retain solicitors being able to recover compensation. The solicitors accepted payment to carry out the conveyancing and then doesn't do it. It admits it's an obligation to do it. There is a public interest in the solicitors being held to account for that. And I don't think my learned friend disputes that. So, sorry, hello, my Lord Hodge.
You have focused on the public interest on holding solicitors liable for negligence, but given your presentation about the importance of the protection of property rights which are conferred, notwithstanding the illegal contract on which they originated, is there a public interest in maintaining coherence in the property law?
Yes, there's a public interest in it. First of all, coherence has to apply across the law. So the criminal law, civil law, and the civil law includes property law and claims for professional negligence. It includes the whole gambit. There has to be coherence in that. And there also needs to be certainty. There's a public policy in certainty. And if the law recognizes that property transfers, that has defined and certain results.
You've emphasised today the property law consequences, and you've referred us to the passages in the Court of Appeal's judgment which discuss that. It just seemed to me that if you're right about that, then the public interest in certainty in property law would be a countervailing factor.
I would adopt that. I think that must be right. The proportionality. My learned friend has spent some time in the position of the mortgagee, and I don't want to, and I've already taken you to the mortgagee's claim, but there is a coterminous, conterminity. There is a confluence of interest between the mortgagee and the mortgage and the mortgagor in this case, in that it is in both their interests that the solicitors should have done their job. And I've already made the point that it's also in the mortgagee's interests that the cause of action which follows from that should be in place, because it provides the assets with which the mortgage can be paid back by the borrower, which is in fact what's happened here with the money that was ordered. And then the fact that the solicitor did not allege fraud in his statement, well, it's worth perhaps a little diversion to see what the solicitor did say in his statement. And my learned friend says, well, he may not have known about the fraud. This was the statement relied on in the trial of these proceedings where the illegality defense was being run. And the solicitor, of course, as you will have picked up from the judge's judgment, chose not to give evidence orally in the proceedings. But if we turn to his statement at page 239, paragraph 6, towards the bottom of the page, 239, described how Maria Grondona was one of those introduced to me as a client by Mr. Mitchell, and Mr. Mitchell brought her into the office at least once. He says, I have no lingering visual impression of her. I don't think I need to read the next bit, but he gave me to understand that she was the girlfriend or fiancée of his nephew. I acted on her behalf in connection with 2 aborted transactions before her purchase of the property. The property had originally been bought by Mr. Mitchell with a loan from B.M. Samuels. I understand that Miss Grondona wished to buy the property from Mr. Mitchell, so I acted for both parties at least twice before. I saw no objection to dealing with the transaction on behalf of both the parties, and indeed they consented. And then paragraph 7, I do submit, is significant because he says, as I expected, Maria Grondona obtained a standard mortgage with Birmingham Midshires, and I received instructions in connection with the advance. The purchase was, I recall, relatively uneventful. And what comes across here, and it brings me into my next submission, is really how the getting of the mortgage was part of the background to what the solicitor had to do. He does nothing in his statement here setting out about how he was in some way central to the fraud, as my learned friend submits. What one has is a perfectly ordinary history of, as you would expect, and as we see looking at the chronology of the facts and issues, the borrower does their own application form for the mortgage and persuades the mortgagor to lend the money to them. And then the solicitor comes in at that point. And at our case, on page 88, paragraph 45, we submit that, as the Court of Appeal said in paragraph 35 of their judgment, the solicitors admitted obligations and failings related to the registration of the title. That's the 3 titles my lady, Lady Black, identified. But the history of how their client had procured the finance necessary to obtain that title was, we submit, as the Court of Appeal held, irrelevant to what the solicitors were required to do. And then indeed we make the point, indeed by the time of the solicitor's negligence, the history was even more distant because the money had been paid away. And we refer to and rely upon the decision of the Court of Appeal in Sweetman and Nathan. Now, except, of course, the application before the Court of Appeal, but its reasoning is nonetheless, we submit, persuasive. We've set the facts out at paragraph 46, but in essence, Mr. Nathan, a solicitor, and his client, Mr. Sweetman, fraudulently persuaded a bank to make the client a loan to enable him to sell a property to an identified purchaser. And the misrepresentation was that they needed the full amount of the loan to discharge an existing charge when in fact the existing charge was really rather small, and this was a fraud to get money out of the bank. The solicitor was retained for the necessary conveyancing. The purchaser turned out to be worthless shell company, with the result that the client could not repay the loan to the bank. And the client sued the solicitor for failing to discover the fact that the purchaser was a shell. The solicitor sought to strike out the claim on the basis that the client's losses arose out of his own deceit. And can I go to the judgment? It's at tab 7 and go to page 498. And at paragraph 42, Lord Justice Sheeman recorded a submission made by counsel, not the eminent counsel that appears in this case, but the other one in the claim, recorded a submission by counsel, the following submission. Someone, a different eminent counsel, I should say, he posited the following case. Someone wishes to purchase a house. The solicitor negligently fails to discover a covenant which renders it worthless. The buyer, in ignorance of this, pays by false representations as to the level of his income. Before the fraud comes to light, the mortgage is repaid. He submitted that these facts would not prevent the buyer from suing his solicitor. The loss was properly described as flowing from the solicitor's negligence, not from the buyer's fraud. And if one goes down to paragraphs 62 and 63, and the reason I draw attention to that example because it is helpful in identifying what's central to the cause of action. But paragraph 62 and 63, Lord Justice Sheeman, considering the illegality defence, said this: what remains is a pure question of public policy. Should the courts refuse in principle to lend Mr. Sweetman their assistance in suing Nathan when they were jointly engaged on a fraud? If Mr. Sweetman were suing Coutts for, say, failing to transfer the money to him, then one could see a strong case for refusing him the court's aid. And that perhaps ties in with the question my Lord Hodge asked of my learned friend this morning. However, he is suing his fellow fraudster. If he were suing him for writing such an incompetent letter, Coutts had grasped in time that there was a fraud going on and had therefore refused to lend the money, and that therefore a profitable deal had fallen through, again one could see a strong case for refusing him the court's aid. He is not, however, not doing this. He is suing his solicitor for negligence, which is conceptually entirely separate from the fraud upon which both of them are engaged. And I do submit that is a helpful analysis when it comes to the question of centrality, because the question is not, as my learned friend puts it, whether the retainer of a solicitor is central to the illegality. The question is whether the illegality is central to the cause of action. And here the cause of action is for a breach of negligent failure to register proprietary interests which had transferred. And then dealing with the analogy by counsel that he said somewhere, if I can find it, and that he found it a helpful, the one that had force in it. Yes, paragraph 65. In the present case, Mr. Sweetman's action against Nathan's erstwhile partners can be reliance upon any part of the fraud assumed to have been committed. The fact that damage might not have resulted but for a decision to deceive Coutts is irrelevant to his cause of action. There is force in the analogy with the case referred to in paragraph 42 above. And as I said this morning, whilst the reliance I fully accept in the light of Patel and Mirza, reliance is not the touchstone of liability in this area. Nonetheless, many of the factors relevant to it are plainly the factors relevant to centrality. The concept of centrality hasn't come out of nowhere in Lord Toulson's test. And if you can see that the fraud is, as the Court of Appeal said in this case, the case we're considering, that the fraud was really part of the background story to the breach of the obligation, that must be right. If one asks oneself this, we know that Mr. Patel and Mr. Mirza were engaged in serious wrongdoing. They were planning to engage in insider trading. The only thing that prevented the dishonest scheme going ahead was the fact that the anticipated insider advice wasn't forthcoming. It wasn't because either of them repented of their dishonesty. The court held, notwithstanding the fact that Mr. Patel had paid his money across to Mr. Mirza for a dishonest purpose, that the court would nonetheless assist him to get it back. Ask oneself this: supposing the facts were changed slightly and it turned out that Mr. Patel had needed to transfer the money from another source. Suppose that the source of money, suppose that he had paid the money to Mr. Patel through an intermediary, perhaps a solicitor, and the intermediary had lost the money or paid it away to the wrong bank account. Could he not sue to recover it? The answer is plainly he could, despite the fact that he was the only reason for the transfer was that he was engaged in an unlawful purpose. Or changing the facts again, would Mr. Patel's claim have failed if it turned out that the source of his money was from other inside deals that he'd made? The answer must be submitted, I respectfully submit, must be no, on the basis that that's not central to what the cause of action was about. And that's, as I mentioned earlier, also consistent with the position adopted by the Court of Appeal in the Ark-Hangelski case. The facts, as I think I've set them out earlier, but it was the alleged conspiracy to seize assets. But the counterclaim was that the assets were only obtained by reason of bribes. And perhaps we should briefly turn to the case at page 251. Page 251 is the head page, but page 252, paragraph 2, you see what the claim was about. The Bank of St. Petersburg was suing against Dr. Arkangelski under personal guarantees. But Dr. Angelski and his wife and their company were counterclaimed for damages in respect of an alleged conspiracy unlawfully to raid and seize the assets of two of their main businesses in Russia, which were owned at Western Terminal and Scandinavia Insurance Company Limited, which owned land at Oniga Terminal. So at paragraph 8, the illegality case is set out in the second part of the paragraph, about 5 lines up from the bottom, paragraph 8. In the alternative, the respondents say that even if the court does accede to the appellant's submissions, the judge ought anyway to dismiss the counterclaim on grounds of illegality. Dr. Arkangelski admitted in evidence that he paid some $160 million in bribes to obtain licenses for the acquisition and developments of the port businesses, the very businesses he was suing over. And at page 282 of the bundle, paragraphs 89 to 91, Sir Geoffrey Voss rejected that. He said that the respondents argued that the corrupt payments made, this is paragraph 89, made by the appellants fatally tainted their counterclaim. It was said that without such corrupt payments, the value of Dr. Anglesey's businesses and real estate could not be maintained. And before us, the respondents contended that the judges had failed to apply patella merza correctly, and they criticised his reasoning to the effect it would be rare for the court to refuse a person the opportunity to vindicate a right on the grounds that the integrity of the system may thereby be imperiled. The judge pointed out that the respondents were contending that the appellant should be prevented from vindicating their rights in respect of dishonest dealings with their property when their property was not obtained illegally. On that basis, the judge said, by reference to the factors illustratively by Lord Toulson, this case seems to me some distance from the appropriate case in which to deprive the appellants and insulate the respondents in the name of preserving the integrity of the judicial process. The respondents argued the judge failed to take into account that one, bribery is a serious crime and civil wrong and is morally reprehensible, and two, there was no relevant public policy which may be rendered ineffective or less effective by denial of the appellant's claim, and three, the appellants could not have profited from the value of the properties without Dr. Ark Anglesey's bribery, and four, an award of damages would effectively reward that bribery. In my judgment, the judge's evaluation was a proper application of the test of patella merza. It would do nothing to prevent or discourage bribery, to deny the appellant's claim for damages for a subsequent dishonest conspiracy. The two events are not as closely connected as the respondents contend. Secondly, there is a strong additional policy in allowing the appellants to vindicate their rights if they're shown to be entitled to do so, for the respondent's dishonest conspiracy to remove property. And then finally, it would not be a proportionate response to the illegality, bearing specifically in mind that punishment for bribery is generally a matter for the criminal courts. The consideration is profit, but I needn't dwell on that for long because it's common ground that this is not for profit of a claim for profit. And I do remind you of the statement of facts and issues which set out that there was a complete cause of action here for the loss of the value of the interest which should have been transferred to Ms. Grondona. Which brings me, I think really I've covered this, to consistency and harmony, but perhaps we should just look at the Theft Act, since that's what my learned friend refers to, and it's at page 705 of the bundle. Section 15. Obtaining property by deception. Now, property includes money by the definition under section 4 of the Act. Of course, the Act itself has since been repealed and replaced by the Fraud Act. But at the relevant time, this would have been the provision. So a person, section 15.1, a person who by any deception dishonestly obtains property belonging to another with the intention of permanently depriving the other of it, shall on conviction be liable to indictment. So the offence here, if there was an offence, and it is important to say that Ms. Grondona has not been prosecuted, let alone convicted in a criminal court. And also, so this is not, and also what flows from that, this is not a case where there is therefore any inconsistency between the claim and any sanction which was imposed by a criminal court, because there has been no sanction from a criminal court. But in addition to that, nor would there have, if she had been convicted under this section, nor would there have been any inconsistency with it in allowing this claim, because what the criminal law is concerned with is the obtaining of the money by deception. There is absolutely nothing illegal or prohibited by the criminal law in relation to the registration of the various property transfers. So there are really 2 points on consistency. The first is that this claim is not in any way inconsistent with or undermining the criminal law. But the second, in a way, as the point that my lady, Lady Arden earlier, denying this claim actually would create an inconsistency, because it would create an inconsistency between the fact that the law recognized on the one hand that this was to the outside world and for all purposes a valid transfer, but then the other says, but we're not going to recognize the consequences of that, which is that if someone loses it on you by not protecting it, you can't recover damages. That, we submit, would be incoherent and inconsistent. We've cited in our case such academic writing as we could find that was relevant. I've already dealt with Professor Burrows' article. I don't think I need to go to Professor Tan's from the University of Singapore, but I do adopt as rather apt his observation on the Court of Appeal's judgment, which it does show that the courts will be astute not to allow the opportunistic taking of illegality defences by professionals. And but as I've set that out in the case, if I could touch briefly on the appellate approach, I'm not sure this is likely to be very controversial. The point arises because my Lord Reid and Lord Lloyd Jones may recall that in the Singularis case, the Court of Appeal had suggested intervention was much like it might be if an appeal court was deciding whether to interfere with a discretion. And Lady Hale in the Supreme Court said that those who follow with should not assume that that Court of Appeal's pronouncement on that point was necessarily right. The Court of Appeal at the time they made their decision, Sir Geoffrey Voss did not have the benefit of the decision of your Lordship's court in the Queen and the Chief Constable of Greater Manchester Police, which considered the appellate approach where issues of proportionality are involved. And of course, it was specifically dealing with proportionality under the Human Rights Act. But there's no reason to think the same test shouldn't apply here, because what the appellants are contending for is the taking away from someone of an otherwise valid cause of action. And the page 409, we have the report of the case, but the relevant passage is at page 432. And it's paragraph 64, and it's the judgment of Lord Carnwath. And he said, in conclusion, the references cited above show clearly, in my view, that to limit intervention to a significant error of principle is too narrow, and an approach at least if it is taken as implying that the appellate court has to point to a specific principle, whether of law, policy, or practice. Below. The decision may be wrong, not because of some specific error or principle in that narrow sense, but because of an identifiable flaw in the judge's reasoning, such as a gap in logic, a lack of consistency, or a failure to take account of some material factor which undermines the cogency of the conclusion. However, it is equally clear that for the decision to be wrong under the civil procedural rules, Rule 52, 11.3, it is not enough that the appellate court might have arrived at a different evaluation. As Lord Justice Elias said in the Queen ex parte C and the Secretary of State for Work and Pensions, the appeal court does not second guess the first instant judge. It does not carry out the balancing task afresh, as though it were rehearing the case, but must adopt a traditional function of review, asking whether the decision of the judge below was wrong. It follows that in the present case, it was sufficient for the Court of Appeal to consider whether there was any error or flaw in the judge's treatment of proportionality. Here, of course, is a slightly unusual position because the Patel and Mertz approach had only just come in before the Court of Appeal hearing, but wasn't available for the judge. But in essence, we submit that this is the approach which applies on the review of the Court of Appeal's decision. But we say it matters not because the Court of Appeal's decision, for the reasons we've been submitting, is right in any event. So we then summarize our case at paragraph 62 on page 93. We point out, well, the starting point of action that the respondents didn't do the very things that are being sued for not doing the very thing that they admit they should have done. For the reasons we submitted, denying the claim will not enhance the policy against mortgage fraud. And then a point I do want to emphasize, this would allowing the illegality defense to succeed in this case would in fact amount to a significant widening of the circumstances in which the illegality defense applies, because it would be applying it in a professional negligence context where the claim is not for performance of the illegal contract itself, but for performance of a separate contract which and breach of duty which postdate the alleged illegality.
Shows what the position would have been under the old law.
I'm sorry, my lady,
Case for what the position would have been pre-Patel.
I'm sorry, my lady, I missed the first part of that. I didn't hear the first part.
My apologies. Could you just tell me which is the best case in your view to support your submission that this claim would have lain pre-Patel and Mertzer?
Well, Sweetman and Nathan is clearly very much on point. But also, in a sense, Tinsley and Milligan and Patel and Mertzer themselves are, because in both those cases succeeded where the person claiming did not, where the alleged illegal behavior was really part of the background to the claim in a sense. And as I say, if you take the facts of Patel and Mertzer one stage further and imagine that there'd been an intermediary who was being sued, then you're in squarely into this case.
Thank you.
Yes, I think there's not. I think I've I'll be pleased to hear I've covered it all, but, unless there are any specific questions any of your ladyships or lordships have for me.
No, I think not. Well, in that case, thank you very much, Mr. Warnock. And we'll turn now to Mr. Pools in reply.
A few points only. My learned friend started by looking at the statement of case issued by the bank against the solicitors. That was never pursued. Those were bare allegations. They were never investigated. No findings of fact either way were ever made upon them, and they cannot play any part in the role in these proceedings. They are effectively written in sand. My learned friend, early on in his submissions, also warned against the risk of an additional penalty in civil proceedings to those that would be imposed in criminal proceedings. And you'll recall that a few moments ago, when looking at the Theft Act, he said, on the contrary, that Ms. Grondona had never been prosecuted, let alone convicted. And so there is no question of duplication of sanction. There is no question of inconsistency or undermining the criminal law. The position is a question of public policy arising out of the circumstances giving rise to this civil claim. We entirely adopt the questions which were put to my learned friend, Mr. Warnock. The conspirators, Mr. Mitchell and Ms. Grondona, set out on a mortgage fraud to get the loan. That involved a number of steps, including putting in the dishonest applications, executing the mortgage deed, and instructing solicitors to take the steps in conveyancing. They were all intimately connected steps, and that is what gives rise to the public policy consideration in this case. There is no paradox in recognizing property rights for some purposes, but not providing the claimant with a remedy in this case. That is because the balance of the public policy considerations bar the claimant's claim in this case. That would not prevent her, should she have an interest in doing so, suing an arsonist or taking any other steps, albeit given that her legal title was a bare legal title and that she was effectively holding the property for Mr. Mitchell, there must be a very real question mark as to whether, unless there was some question of profit for her, she would have any interest in doing so. But there's nothing about the fact that she could take such a step which is inconsistent with the court's application and operation of the overarching public policy which we submit is correctly to be applied in this case. My learned friend took you to paragraph 35 of the judgment of the Court of Appeal. And perhaps I can remind you of that. That's on page 116 of the bundle. It's at the end of the passage where the Lady Justice Gloucester is considering the steps taken in the conveyancing process and the faults of the solicitor. And she concludes by saying the various steps which should have been discharged, and concludes by saying the illegal features of the agreement between the claimant and Mr. Mitchell were irrelevant to the obligation. With respect, in our submission, that fails to address the issue. They are irrelevant to the obligation insofar as they do not impact directly upon the obligation. They are relevant and central to the balancing process which she embarks upon 3 paragraphs later. Negligence was never an issue. The question is the public policy question. My learned friend then took you to the statement of Mr. Mann to make a point that he doesn't comment that he was central to the fraud. At a time when practitioners are being warned very firmly as to the incorporation into witness statements only of material statements, I repeat the submission that there is nothing relevant to the issue in the case that Mr. Mann could have said in his witness statement. My own friend then took you back to my glorious failure in Sweetman. I made my principal submissions on the case this morning. There is an obvious distinction between this case and Sweetman. Sweetman involved obtaining money from Coutts Bank by way of mortgage fraud, dishonest misrepresentations, in order to discharge Ms. Shawdale's profit share in the original sale agreement. As you'll have seen from the facts of Sweetman, it was a flamboyant case. 34 acres of Lancashire moorland were said to be worth, I think, £12 million because of mining rights. That was somewhat unlikely given that it was in the middle of the national park and there was no vehicular access. The true value of the plot was £12,500. A few extra zeros had appeared on the way. That perhaps coloured everybody's view of the participants in the matter. But be that as it may, Miss Shawdale was going to receive a profit share, which could, on on that basis, have been many millions of pounds, but was prepared to be bought off for £200,000. In reality, obtaining money from Coutts Bank in order to buy her out could have been undertaken for a number of reasons at any time, regardless of whether or not the property was going to be sold on to Darvist or Darvis, as the case may be. There was no direct connection between the need or the desire to obtain that money and use it in the way that it was, and the sale which was in fact proposed at that time to the shell company. Whereas in the present case, of course, the retainer of the solicitor, the steps to be taken by the solicitor were intimately connected with the mortgage advance. And this claim flows directly out of Ms. Grondona's obligation to repay that money to the Building Society. Incidentally, if one looks back at paragraph 65 of Sweetman, which I don't propose to take you to, but just for your notes, it is clear that a contributory factor to the decision of the court was an approach framed upon reliance for the purposes of a course of action, which obviously is not a distinguishing feature which can survive the decision in Patel. My other friend made a number of submissions as to how the outcome in Patel might have been the same regardless of, or rather, might have given rise to a claim had there been an intermediary who had made some error in repayment. These issues of public policy are absolutely fact sensitive. My learned friend might be right in respect of the transactions he postulates, but imagine rather a version of Patel in which the money is not being paid over for the purposes of some insider trading, but is being paid over to a person being retained to murder somebody. And imagine that in those circumstances, the intermediary has paid the money away. Would the application of the public policy balancing exercise set out in Patel in fact permit the person commissioning the murder to recover the money in those circumstances? We would submit that it would not. And that is what demonstrates the importance of the balancing process for which we contend. Similarly, in Archangelski, the two events were expressly, the two incidents of dishonesty, that is to say, the dishonesty on the part of the counterclaiming defendants in obtaining profits by means of having bribed in eye-watering figures people here and there, was on any view remote from the fact of the alleged unlawful conspiracy to seize the companies, enhanced or otherwise by bribery. The bribery might have had some effect upon the valuation down the road, but it had no involvement in the conspiracy to deprive Dr. and Mrs. Archangelski of the companies. And finally, my learned friend said that he prayed in aid the words of Dr. Tan in respect of opportunistic taking of defences. With respect both to Professor Tan, I think, and my learned friend, these can never be opportunistic submissions because it will always be necessary for the party seeking to pray in aid this public policy consideration to satisfy the courts of the public policy considerations which have to be fulfilled in order for this defense to exist. And we submit that has been achieved here, and it is not either opportunistic and cannot be opportunistic because it is the court which polices the exercise. Those are my submissions in reply, unless there's any other matter on which we can assist you. Yes, my lady.
Can I just ask you, I'm trying to see where the boundaries lie of your submissions. Supposing that the money for the purchase of the property had been stolen from a third party, or maybe kept back from tax that should have been paid, would there be an illegality defence then when the solicitors failed to register the title?
The two alternatives might be very different.
They might.
Keeping back from tax, I think I would be hard-pressed to formulate a public policy balancing exercise which brought the public policy into play. Money palpably obtained by raiding the bank that morning might well be in exactly the same category as the matters with which we're presently dealing. It is the direct product of dishonest behavior.
But it differs from this situation in that your submission is that the solicitors were a necessary part of the whole transaction in the example we've got before us, but in the bank robbery, not.
That is true, and therefore that might be closer to the line I accept. But nevertheless, I can postulate, at least, that the balancing exercise might look very different. Why would the bank robber be entitled to bring a claim in damages in respect of a fund of money that they palpably had no right to?
Thank you.
My lord,
Yes,
anything else?
I think we seem to have no more questions for you, Mr. Pools. So I spoke too soon, Lady Arden.
Sorry, could I just ask a question, if I may, about the passage at page 82, which you took us to from the judgment of the Chief Justice of Canada, Chief Justice McLaughlin?
Yes.
And as I understand it, what she is saying is you can't condone and condemn at the same time. The law can't condone on the one hand and condemn. That would be an inconsistency.
Yes.
Would you say that Lord Toulson is actually going rather further than that? He's saying, well, you could have an inconsistency, but then you have to get into the balancing exercise.
Lord Toulson is saying we must not, in our submission, we must not be hidebound by forms of action, effectively. The chains of Lord Denning are not rattling us even now. But we apply the public policy considerations by looking at the totality of the picture and undertaking the balancing exercise. And that is why in our submission, the very helpful passage of Mrs. Justice McLachlan is absolutely applicable in the present context. If, as it were, you alter the one word I suggested you alter.
It is possible she's saying something, putting a rather higher test by saying the integrity of the law requires that you cannot both condemn and condone.
I'm not sure that she's applying a higher test. I think she's framing it in a rather more formal fashion, Alcibiade.
Thank you.
Well, thank you very much, Mr. Pools. We're grateful to all counsel for your submissions in this interesting case. We'll take time now to consider our decision. The court will now adjourn.